I know that it is time out of your day, but hopefully the webinars are a great way of, you know, getting the information across. Today, what we're going to be talking about is taking on a new employee and those important things that you need to know, most of which you probably do know, but it's good for a refresher. But probably also a few other little things that might pop up that you might not already know. Now, the purpose of this particular presentation is as a result of quite a few member queries that I do get, and it's a part of a two-part series that I will do as a webinar. Part one being taking on an employee, and then part two will look at engaging contractors. Now, the engaging contractors one I've done at trade nights in the Riverina and on the South Coast. But if you missed the trade nights, or if you want another refresher, you know, it's a good webinar to sort of tune into. So keep an eye on your webinar calendar for further details about that, and of course e-news and building news for the date of that webinar in the near future. So as with all of my webinars, I always include a general disclaimer. Any advice provided in this session is general advice only, and if you've got queries sort of specific to your situation, by all means, please let me know. My contact details will be at the end of this presentation. So in terms of what we're going to cover, the list looks huge. It's not that bad, but these are sort of all of the different things that you need to know as an employer when taking on new employees. Now, a lot of you might already have employees, and that's fine. A lot of you might be sort of thinking about, you know, growing your workforce. So all of this information is going to be relevant to you. Now, what I've done is it's a basic overview. I don't look at rates of pay or anything like that. That can all be provided if you contact me directly, just because we sort of deal with so many different, you know, modern awards under the construction, in the construction industry. And sometimes it's better to have a chat to determine what is best for you and your business. With I suppose recruiting and those sorts of things, again, it's general guidance, mainly because each person, each company or workplace is going to have a slightly different way of doing things. But what I'm looking at doing is just sort of giving you a few pointers to get the ball rolling. And like I said, just reminding you again about what your obligations are as an employer. So let's get into it. One of the things that the Fair Work Act provides are these wonderful things called the National Employment Standards, or the NES. Now, for those of you that have heard me speak about employment matters, or, you know, you've contacted me about sort of employment queries, you know, I'll often mention, you know, the minimum standards required under the NES. This is all provided for, like I said, in the Fair Work Act, and there are 10 minimum employment entitlements, which we'll go through now. Please note, though, casuals are not eligible for all of the NES entitlements, only some of them. So as we're going through, you know, write down your questions and you can ask them at the end. That's not a problem at all. But also, hopefully, you know, this is a good refresher for you, and, you know, you are compliant with your obligations as an employer. So we look at maximum hours of work per week. It's 38 hours plus reasonable extra hours. There's often a misconception about the 40 hours. It's definitely 38. I know that with awards such as the Construction Award, we do have a provision for RDOs, which may lead to a 40-hour week so as to allow for the accrual, but the NES provides for 38 hours. Certain employees can request changes for flexible working arrangements. which is number 2. Number 3 is up to 12 months of unpaid leave, as well as the right to request an additional 12 months worth of leave. Sometimes workplaces will have something specific, which is additional to the NES requirements. Annual leave, 4 weeks of paid leave per year, plus an extra week of leave for some shift workers. Personal and carers leave, this is 10 days paid personal and carers leave per year, as well as 2 unpaid days of carers leave, and then 2 days of compassionate leave as required. When we also have a look at the next lot, we sort of delve into the other types of leave which might be available, including community services leave. So if you've got an employee that's part of, the RFS, leave for jury service, again, sometimes leave might be paid in those circumstances. We've got long service leave, keeping in mind that, say for example, the construction industry is covered by the Portable Long Service Leave Scheme. We could be governed either by the NES and or, the relevant state or territory legislation. Then we look at the public holidays. We've also got minimum requirements for notice of termination and redundancy, and that includes redundancy pay for some employees. And that could be, say, up to 5 weeks worth of notice for a termination and up to 16 weeks worth of redundancy pay, given the situation. And then the final one is the provision of the Fair Work Information Statement. Now, just touching on what I mentioned before, casual employee entitlements under the NES. So they are only entitled to those things relating to accrued unpaid carers leave, unpaid compassionate leave, community services leave, and the provision of the Fair Work Information Statement. So the next question that I ask when, somebody's called me up or they popped into the office to say that they're looking at taking on an employee, following on from sort of running through their obligations as an employer, I sort of just ask the question, what type of employee do you want? On this slide, I've got listed full-time, part-time, casual, daily hire and apprentices, and I've broken them all down. When I talk about types of employment, this is what I mean. I sort of don't look at the job description. I look at sort of what you need them for in terms of how many hours and whether or not you're looking to pay for their entitlements. So breaking it down, again, keeping in mind the NES, a full-time worker works an average of 38 ordinary hours per week. The notice periods are per the award, or if nothing is provided for in the award, it will be the National Employment Standards. The purpose of the National Employment Standards is to ensure that employers aren't doing the wrong thing and are sort of contracting away from those minimum entitlements. We have heard of instances where, and it's not construction industry, we hear about it in, say, retail and hospitality and those sorts of things. It's not to say that it doesn't happen in construction, it's just that I haven't heard about it, is that sometimes people can say, pay somebody $10 per hour because it's good money and it's cash in hand, but it's contrary to the NES. So we just have to be careful that, what we're doing isn't contrary to what our minimum requirements are. Again, going back to the types of employment, part-time employees work less than 38 hours per week, but they do have reasonably predictable hours of work. Sometimes you'll hear about sort of somebody who, only works 3 days a week, but they work Monday, Wednesday, Friday, and they do 9 to 5. That would be reasonably predictable hours of work. Part-time employees have the same benefits as a full-time employee. However, their entitlements, say for example their annual leave, is calculated on a pro rata basis based on the hours that are worked, and the notice periods are per the award or the NES, whichever one prevails. The next one we look at are the casual workers. So they generally don't have guaranteed hours of work, and nor are they regular. However, we do know that sometimes they are guaranteed hours of work when you're really busy, and they're going to be doing regular hours of work. I suppose the difference between them and what we would deem a permanent role is that they're not entitled to the paid leave entitlements. Now, there's no notice periods that apply for a casual worker, but for 1 day. And then we sometimes have award-specific entitlements for your casual employees, such as in the building and construction award, the casual conversion. When we look at daily hire is different again. It's similar to a full-time or part-time employee who accrue their entitlements, but they're only entitled to 1 day's notice to terminate their employment. Now, the purpose of this particular arrangement, and this only applies in very few circumstances, is to, I suppose, allow for people to be able to turn up to work. They get paid an extra loading, which is for essentially a follow the job, which is more than the casual rate, but again, there's not as much certainty as if there was a full-time employment arrangement. Now, the other thing is if they're a tradesperson, say for example a carpenter, they're also entitled to an extra hour before termination to clean, sharpen, collect and transport their tools from site. Now, apprentices, and I've got a full slide or a full section of slides dedicated on apprentices, but essentially they have the same entitlements as a paid leave, the same entitlements to paid leave as what a full-time employee would have, or a part-time employee if they're engaged on a part-time basis. Now, other entitlements may be specific to the award. So, for example, with the construction industry, we have a travel allowance entitlement at a percentage of the daily rate, which is applicable to apprentices. Again, if you do have any questions about sort of taking on an employee and what type of employment would suit you better, by all means, please give me a call. So then we look at where to start. We have to think about recruiting, how we're going to go about doing that. Then we've got the interview process, and then when we find the right person, what do we do? So the first question that I sort of ask is, what is the position that you're trying to fill? Now, we've determined that we sort of might want a full-time employee to come on. So we then look towards a position description or a list of duties that this person would be required to fulfill. This can then also be included in a letter of engagement or a contract of employment. And I suppose this also gives you a benchmark as to those, I suppose, things that you want this employee to achieve when working for you. It's also good for the employee who's making the application for this particular job to know what's expected. Now, just as an example, my position description here with HIA when I started was exactly how it was described on the application. So I was very, very well aware of my roles and responsibilities here, and that's exactly the same as what you should be thinking when you're thinking about the position that you're trying to fill. Now, from a business perspective, you then also want to look at the skills and qualifications that are required, what experience would be suitable. If you want to start training a new person, such as an apprentice, and then you also then look at supervision, how you monitor performance, what personality types would suit your existing workforce, and then you'd go about advertising the position. Now we have oodles and oodles of possibilities available. We've got the newspaper, we've got notice boards, word of mouth, employment agencies. We could put it on Facebook, seek.com.au or LinkedIn. They're all very, very popular means of advertising a position. Another thing that does pop up quite a bit is Joe Blogs from down the street. I know him, his son wants to do an apprenticeship, can I take him on? That's fine. If you can, I suppose, go around advertising the position and go through the word of mouth, then that's perfect too. The next step in the process is to, I suppose, assess and review the applicant. So in sort of a more formal arrangement, you might have an application and interview procedure. In sort of a more flexible arrangement, you might just have a meeting on site or in your office to determine whether or not this person will be suitable for the tasks that you want them to do, but also a fit for your workplace. Now, if you do go through and do an interview process by in person or by phone, whichever one suits you better, and you can also ask them about relevant experience, what skills they have, what sort of they're looking to do with their career, for example. But one of the things that you should avoid doing is asking personal questions, anything that's intrusive or irrelevant to the role that you're advertising, because we don't want it to be seen as inappropriate or discriminatory. Once you've gone through the interview process or you've had your chat with Joe Blog's son from down the street, then there's always the potential for checking an applicant's referees and then making your decision as to whether or not they would be suitable. If all things going to plan, you can then offer the employment to the suitable candidate. Now, my general recommendation is, and this is different depending on who you speak to, but I would generally recommend making the phone call to let them know that they were successful, and then sort of just asking the questions as to when they can start, but to also follow this offer up in writing. Sometimes people ask for a confirmation of the offer in writing so that they've got something that they can rely upon and they can feel comfortable with when sort of going home and making the decision. My other recommendation is to also just advise those that weren't successful. It's more a courteous thing than anything else. There's no mandatory requirement. It's more out of courtesy. So then we look at probation periods. All things going well, the probation period can be successful or it can be unsuccessful. So when it's successful, it means that they just continue working for you. When it's unsuccessful, that means that we just need to, I suppose, move on and potentially restart the process of looking for another suitable candidate. Now, the purpose of probation is to assess if the employee is suitable for the role and for the business based on the skill and experience that they've mentioned that they have, and all the training and the fit for the business, and whether or not it's going to be a suitable arrangement for both you and for them. Now, there's no legal requirement and there's nothing provided for in the legislation which says how long the probation period should be or if you should have one at all, but a common length is about 3 months. Some people have something longer, some people have a couple of weeks, some people have a day. It all comes down to you and what you decide as the employer. One of the misconceptions is that an employee doesn't get the same rate of pay or doesn't get paid leave or anything like that, and that's untrue. An employee on probation is entitled to the same entitlements as what they would be were they already engaged with you or had been working with you for some period of time. So that's probation. We then look at the Fair Work information sheet. What this document is, it's provided by the Fair Work Ombudsman and sort of sets out those the basic information. You're required under the NES to provide this document to all of your new starters, either before or soon as possible after they start in their new role. Now, it goes through, and I know that it's very hard to see, it provides information about the NES, the right to request flexible working arrangements, modern awards, making agreements under the Fair Work Act, individual flexibility arrangements, freedom of association and workplace rights, termination of employment, right of entry, and the role of the Fair Work Ombudsman and the Fair Work Commission. The statement can be given to new employees either in person, by mail, by email, in terms of a link to the website or a PDF document, or by fax, but most people don't have a fax anymore, so I think that one is now becoming outdated. It's also available in 30 different languages. So if you've got a person that doesn't speak English, or English might not be their first language, you can essentially jump on the Fair Work Ombudsman website, have a look and download the language suitable for your new employee. Now, I just want to sort of take a step back, and once we've sort of provided the offer, we've given them the Fair Work information statement, the ball is rolling, what are the things that we need to look at when the new worker commences? One of the things that I think a lot of people fail to do is to provide a proper induction. Now, this is not a work health and safety induction, although that does form part of it. But it just looks at those basic things: who you and your business are, what you do, where the bathrooms are, where their work desk or they're going to be working, what's required of them in terms of tools and those sorts of things. It gives you a chance to also finalise any other documentation that might be outstanding, but then it also is a good lead into running through your WHS induction, for example, and going through any workplace policies and procedures that you do have. What you then do is you then give them time to settle in and work into the role, either in accordance with, the probation period, or if there's no probation period, then we don't need to worry about it. Remember that when starting a new job, it can be quite daunting. People are very excited, people are a little bit nervous. So we just need to keep that in mind. And I also find that having that first induction when they start work with you is really, really helpful. I know that when I started here with HIA, we have fantastic induction going on, and I know that they've done some other improvements as well. And, it just really helps you as an employee to hit the ground running. And that's the only recommendation that I can make is, okay, put yourself into their shoes. What information would you want to hear on your first day? So then moving forward, we're jumping into the information that we need from the employee for your records. So we look at the basic info, so contact details, of course their bank account details for the payment of their wages, other relevant information that can be handy either when they're out on site or, if they've got any medical conditions or allergies that we need to be conscious of. And then looking at if they've got any applicable qualifications. So for your on-site guys, we would want to make sure that they've got a white card. If they're in the ACT, they've got their asbestos awareness training. If they're doing any high-risk work, that they've got the applicable license, so on and so forth. This would also be, retained and kept on your employee records. So whether you have a manila folder with Joe Blogg's name on the side, or if you've got an electronic filing system, whatever it is, just make sure that you get all of the information there. Another thing is to also ensure that you get an emergency contact detail, because whilst we don't hope for or want any emergencies to occur. If anything does happen, we want to know who we can contact in those circumstances. Other information is a tax file declaration. This form is now available via the ATO website. All of the links in this presentation are hyperlinks, so you should just be able to click on the link and it should bring up the form. You can also go to the newsagent or write to ATO and get them to send you out some copies. But this document essentially is to be completed by the payee to provide their tax file number details, and it must be completed by you, which your section is down the bottom, and submitted to the ATO within 14 days of the new employee commencing work with you. The other thing that we also want to do is make sure that we get some super fund details. And this is for your compulsory super guarantee contributions. As we all know, the current rate is 9.5%. For those of you that pay more, that's fantastic. Just make sure that in the event where you have the details, or you need to get the details, that the standard choice form is provided so that they can nominate their super fund. Alternatively, if they don't, you can then pay into your default fund. Most of the time for the construction industry, it's probably CBUS or something similar. If they don't provide anything to you, it just goes into your default fund. If you don't have a default fund, it's probably a good chance to sort of look back through and do some research and see who's going to provide you with the best super fund. Now, I'll go into super a little bit more in some later slides. But the other thing is, sometimes people are just super keen to start work and they'll have a copy of their super statement from the last quarter or something like that, and they'll just give it to you with the rest of their documentation. So then we've got record keeping obligations. On the left, I've just got some general information, and on the right, I've got some information regarding pay slips. Now, any employee record must be kept in a form that's readily accessible by a Fair Work inspector. Now, it's becoming more common that audits are happening in relation to industrial relations and payroll, and we're sort of seeing this increasing, particularly for your commercial guys, but it is starting to creep over into sort of the bigger res jobs. Having your records in place and readily accessible is going to be really handy in those situations as well. Now, the basics are they need to be legible. Most people use an accounting system now. If they're in writing, just make sure that you can read them, and they also need to be in English. All employee records need to be kept for 7 years, and we cannot change them except for the purposes of correcting an error, and they must not be false or misleading to the employer's knowledge. One of the things that does pop up when I am speaking to people, and this comes from people that have had employees for forever or people that are starting out, is what needs to be included in a pay slip. So we've got the employer ABN, the employee's name, the period that the pay slip covers, and the date of the payment. Obviously, your before and after tax amounts. Then you would have something to the effect of an hourly rate and the hours worked at that hourly rate, including the total, as well as your leave loadings, allowances, deductions, bonuses, and any other separate monetary amounts listed underneath. If you're on a salary, it's just the employee salary rate. Then you also provide information about any deductions and then your super contributions made during that particular pay period, including the fund name and or number. This needs to be issued within 1 day of being paid. Electronic form is fine if you've got the employee's email address, or a hard copy provided to the employee is also acceptable. So then we look at whether or not my employee is covered by an award. Now, this is from an info sheet that's available from HIA, and it's specific to the construction industry. Now, step one determines whether or not they're potentially covered by an award, and step two looks at that information and then determines what award it is. For a lot of you, it's the Building and Construction General On-Site Award. For also a lot of you, if you've got people that are working in the office, the Clerks Private Sector Award is also a common one, and that covers all of your clerical and administrative employees. In the event where you've got, say, a salesperson in a display home, for example, give me a call, because there are some other questions that I need to ask to determine whether or not they're actually covered by the Clerks Private Sector Award, or whether or not they're covered by another award, such as a miscellaneous award. This can be really good if you're sort of branching out, or if you sort of fall between having a joinery workshop, but then having some guys that do go out on site. If you do have any questions, like I said before, and I'll keep saying it again and again, if you have any questions, please let me know. So then we look at the difference between a letter of engagement and an employment contract, because this is the next step. We want to document the employment arrangement. A letter of engagement is suitable for most of you. Now, it can be used for full-time, part-time, or casual employees, and it's, I suppose, in accordance with an applicable award or enterprise agreement. It sets out the main terms and conditions, as well as notice periods and those sorts of things. There is a template available on the Fair Work Ombudsman website, and as you can see down the bottom, I've got the logo for HR Docs. I can prepare the documents on your behalf through this product. All I do is send you out an information sheet. You send it back and I can prepare the documents for you. Your first letter of engagement is free, and then all other letters of engagement after there are charged on a small fee basis. The alternate is an employment contract. Now, this is a little bit more comprehensive than the letter of engagement, but essentially sets out the legal agreement of the terms and conditions of the employment relationship, which may not be covered by a modern award. What you can't do, and like I mentioned before when we were talking about the NES, is we can't contract out of our minimum obligations as an employer. If you have specific queries, or if you're looking to have a comprehensive agreement in place, give me a call, because I can answer any questions. Sometimes I'll have people come to me that want an employment contract, but then after sort of going through the situation, most of the time the letter of engagement is just a more suitable document. So now let's look at the legalities. These are the things that apply for all employees, irrespective of if they're new with you or not. And we'll start off with the tax. You're required as an employer to withhold pay-as-you-go withholding tax. This is PAYG. Now, the basis is you need to register with the ATO, and then you need to withhold tax from certain payments made to employees, company directors, office holders, under voluntary agreements, labour hire arrangements, or where an ABN has not been quoted in relation to a supply. An example of that would be where your contractor has not provided you with an ABN on their invoice. As you can see on the right-hand side, I've just done a quick calculation for Joe Bloggs. His gross pay was $800. This calculator is available on the ATO website, the hyperlinks to your left, and this determines, in accordance with the tax rate tables, how much tax you withhold from each payment made. It doesn't look at anything else, it just looks at the tax component. If you've got an employee working for you that has a HEX or a HELP loan, so they've been to uni and they're sort of over the threshold and they need to make repayments, there is actually the option for you to tick the box to say that yes, they have a loan, and what it does is it takes that into account as well. Now, your annual reporting requirements for your PAYG is due on the 14th of August. The taxable payments annual reporting, and this is for payments made to contractors, is due by the 28th of August. Your payment summaries, which are those documents that you give to your employee regarding the amount of tax withheld for a particular financial year, is to be provided to your employees no later than the 14th of July in each year. So they're probably some pretty important dates for you to put in your diary or in your calendar on your computer, just so as to ensure that you're compliant with your tax obligations. There are a whole stack of other PAYG reports which I won't go into, and the list on this page, which shows all the dates, is non-exhaustive and doesn't apply to any of your other reports that you need to do, like your BAS and those sorts of things. This is all strictly PAYG. So then we look at payroll tax. A lot of people this doesn't apply to. This is strictly for each state or each territory has a payroll tax, which is determined by a particular threshold, and then a tax rate then applies to anything over the threshold. So if you're paying over $2 million per year for your employees, your tax rate, which is current at the moment, is 6.85%. Now, it only applies if your total taxable wages exceeds the $2 million per year. If you're in the ACT, you do need to register, and this is through the ACT Revenue Office. And then you've also got to nominate when you're going to be submitting your returns. This nomination is always subject to the ACT Revenue Office's approval, but could be either a monthly or annual basis. Now, also keep in mind that payments to your contractors are considered taxable wages and are also subject to the payroll tax unless the contract is exempt. Now, if you're not sure, there is a page specific for contractors on the ACT Revenue Office payroll tax website, or alternatively, give me a call. Now, for New South Wales, it's slightly different, and as you can see, the rate is much lower, but I suppose the threshold is much lower too. So what they've done is they've broken down the 750,000 into monthly thresholds depending on the days. So for example, a February threshold would be 57,534, and anything over that amount would be subject to the payroll tax in New South Wales. Again, New South Wales Office of State Revenue website has some great information. If you've got any queries, like I said before, by all means give me a call. So then we look at super. We've mentioned it before, the super guarantee rate is 9.5%. And this is based on the employee's ordinary time earnings. Now, when we look at the definition of ordinary time earnings, and this pops up in a whole range of situations, including the portable long service leave, for superannuation purposes, it means what an employee earns for their ordinary hours of work, including over-award payments, commissions, shift loading, allowances, and bonuses. Now, super is applicable if you pay the employee $450 or more in a calendar month, and you need to make those contributions into the nominated super fund, or if a super fund hasn't been nominated, into your default fund on behalf of the employee. Now to the fun stuff, the portable long service leave scheme. Now, ACT and New South Wales have their own schemes, both of which are very different. The feedback that we do get from members is that they don't really do much with it, but for, submit their returns and or pay the levies. What we do encourage is if you're on site and you've been lodging your returns and paying your levies if applicable, that if you've got long service leave in the kitty, and you're eligible to take it, either take some leave or cash it in. And this is from the employer perspective. From the employee perspective, things are also slightly different. So for you as an employer in the ACT, you'd need to register as an employer and then register your employees. Also notify ACT Leave if their employment is terminated, and submit your quarterly returns and pay your levy. Now, please keep in mind that this portable scheme is only available for building and construction workers who are on site. If you've got somebody who might go out on site or doesn't go out on site at all, but works in the office, but you're a building and construction company, chances are they're not going to be covered by it. If you've got a carpenter, they're definitely going to be covered. So make sure that you go through your employees, and if you haven't registered, please do, because I know that they have been doing some audits of late, and this is both for ACT and New South Wales, and they've actually got the power to fine you if you haven't registered. Now, for ACT, there was a rate change from the 1st of April. Now, this applies for the April through to June quarter. It doesn't apply to the one that you've just submitted. And the new rate is 2.1% on gross ordinary earnings. Let's flip over to New South Wales now. And again, it's for all on-site construction workers. The scheme's funded by a levy on building and construction work over $25,000 and paid by the person for whom the works are being performed. Now, again, you need to register as an employer, and then you need to register your employees, advise New South Wales Long Service Leave Authority if there are any changes to an employee situation, i.e. they leave or you terminate their employment, as well as submitting your returns. If you're not doing it, again, like I said, please do. If you've got any questions about it, please give me a call. So now we get to the fun stuff, the apprentices, and my slides aren't working. So what I've essentially done is just gone through taking on an apprentice. We've got a couple of options available to you as an employer. What you can do is you can take them on direct, which we find that a lot of people do. But then we've also got people that take them on through a group training organisation, such as HIA apprentices. An indentured apprentice is a secure apprenticeship where, after a 3-month probation period, an agreement must be reached by the parties in order to cancel an apprenticeship. And we also need to ensure that we register our apprentices. Now, this is within 28 days of them commencing employment with you. One of the things that we do see from time to time, and I sit on a construction safety advisory committee, and we have been focusing on apprentices and young workers, is that there have been some recent audits done by WorkSafe ACT in terms of workers' comp requirements and those sorts of things. But a few different things have been flagged, including those people that haven't had a training contract in place but are paying the worker at apprentice rates of pay. Now, for those of you that are all sitting there shaking your head and thinking, oh goodness, I can't believe this is happening, it does happen. You'd be surprised at how often it does, but if there's no training contract in place, you cannot pay them the apprentice rate of pay. An apprentice must also attend TAFE, and they need to be registered with what we would call an RTO, so a registered training organisation. Now, TAFE New South Wales and CIT here in the ACT, they are registered training organisations. Once they're registered, a training plan will then be created, which will see the apprentice through their apprenticeship. When we have a look at the roles and responsibilities of an employer, and again, I'm sorry that this slide hasn't come up, there are 6 on the list. Now, first of all, we need to ensure that workplace checks are undertaken prior to the employment of the apprentice. So, you know, we're looking at things like citizenship. Then we look at whether or not, and we need to ensure that the apprentice is provided with every opportunity to learn the skills and acquire the knowledge of the trade, which they have signed up to learn. So, for example, we have signed up a young person as an apprentice. We have agreed that they will be a carpentry apprentice. We need to ensure that we are getting them to do carpentry works so as to satisfy your obligation under the training contract and to provide every opportunity to learn the skills and acquire the knowledge of the trade so that they can become carpenters in 3 or 4 years. We also need to provide a suitably qualified or experienced person to facilitate the on-the-job training. This is sometimes a contentious issue in terms of the supervision. What we need to ensure is that that person that is getting the training is learning from a person who knows what they're doing. We hear about, you know, the first year learning from the third year. We also hear about, you know, the person that might not have a certificate in, let's say, for example, it's an older trade, say bricklaying or something like that, learning from the boss and doing an absolutely fantastic job. That's fine. They just need to ensure that they are learning from a qualified or experienced person. We need to allow them time off to go to TAFE or to CIT to do their training and assessment. We also need to provide them with a safe working environment. Now, this one can't be discounted in any means, and irrespective of whether or not they're an apprentice, you know, we need to ensure that we are, as the PCBU, providing a safe work environment. If you do have any questions about your obligations as a PCBU, that's a whole nother webinar, but I'd be happy, or you could speak to our safety services team who could provide you with further guidance about your WHS requirements. We also need to ensure that the apprentice has access to a full range of the work required to develop the skills and knowledge that they need on the job. And this can be done by having a chat with the RTO who they're, you know, doing their training with, having a look at the competency books, and or looking at the attendance cards. Now, there's no point taking on a carpentry apprentice if they're just going to do skirting boards or they're just going to be doing frames or something like that. We want to try and give them sort of the overall experience because that's what they're going to be learning at Tech and vice versa. Now, the other thing is, and this is definitely covered by the Building and Construction General On-Site Award, is we need to reimburse all fees paid by the apprentice in respect to their apprentice training once they have provided you with, I suppose, your report card is what we like to call them, of their satisfactory progress. Now, in the event where the apprentice has failed the unit, there's no obligation to pay, but we do need to pay when they are successful, and that's in respect of their training fees and the textbooks under the Building and Construction Award. We also need to look at what the roles and responsibilities are for the apprentice, because, I mean, you as the employer have your own, but we want to also ensure that you know what the apprentice should be doing. All of this is set out in your training contracts too, but a general overview is that they need to make every effort to acquire the skill and the knowledge needed to successfully complete their apprenticeship. Now, this is broken down into further components such as accepting instruction and training in the vocation given by the employer or by a workplace supervisor, actually turning up to Tech, and, you know, going through the training that is delivered by the RTO, completing their assignments and their other assessments. They also need to ensure that they maintain their competency record book or their work evidence guide if they've been issued with one. And this is also something that you can check up with them. They also need to notify you if there's something going on where they're going to be running late, or if they're going to be unable to turn up to work, go to tech, so on and so forth. It seems like common sense, but you'd be surprised at how many people don't just pick up the phone and let you know what's going on. Now, the other thing is, in the event where, and this applies to both the employer and the apprentice, is if anything changes in relation to the personal details that are included on your training contract, that you need to notify the person that you sign the training contract with. Obviously, if there are any changes between you and the apprentice, you just have a chat to them and let them know, or notify them in writing, but you also need to notify the person that you signed the training contract with and or the tech if required. There's some benefits of taking on an apprentice. This includes the funding that's available through state, territory and Commonwealth government funding, and I suppose the training organisations, the GTOs and those sorts of things can provide you with further guidance for applying for funding. And Australian apprentices, if you pop that into Google, australianapprenticeships.gov.au, I think the website is, will also provide you with other funding that might be available to you and what you might be eligible for. There are discounts or exemptions from workers' compensation insurance premiums, and that's through the apprentice incentive scheme. Now, it's not available to employers of trainees, it's just for apprentices. The other thing is you also need to ensure that you've got these guys noted on your workers' comp policy too. Then we look at the payroll tax. There are some rebates that are available through the Office of State Revenue in New South Wales and the ACT Revenue Office in the ACT. Check out their websites for further information. Now, like I said before, I'm not a salesperson, but HIA do have HIA apprentices as an opportunity for you to take on an apprentice if you didn't want to do it yourself. We look after everything for you in terms of payroll and those sorts of things, superannuation, sick leave, long service leave, RDOs, and it's all consolidated into one hourly rate for you, which might be beneficial in some circumstances, and I would recommend that if you do have any queries, that you contact our new apprentice manager, Ian McGowan. He's just recently started with us in our apprentices team, and he's absolutely fantastic with dealing with both the hosts and the apprentices as well. So if you do need further information, there's heaps of info available out there. We've got general IR advice, which could be through either myself or another workplace advisor, or the info centre. We've also got the Fair Work Ombudsman, who is the regulator, the Fair Work Commission for Tax and Super, ATO, ACT Revenue Office and Office of State Revenue, ACT Leave, New South Wales Leave, and then we've got the HIA services as well, so insurance services and HIA apprentices. So we're right on time, but if you do have any questions, please feel free to give me a call or send me an email. What I'll do, and I apologise about the slides, is I'll send them through to Kerry and I'll get her to distribute them just so that you can see the information for the apprentices. I'm very sorry, I thought I had the right PowerPoint presentation up. I'll just have to check what happened to those slides. But yeah, if you do have any questions, just type them in the box and I'm happy to answer them.
Thanks, Kristie. I'll just check if any questions are coming through. Always seems complex for especially the people who are working across the borders, doing things in the ACT and doing things in New South Wales as well to keep on top of everything. I'm glad you you're there and you know what you're talking about. It seems very complex to me.
Thank you. It is a complex area, and one thing that might apply in ACT doesn't in New South Wales. It's one of those things where if you're not dealing with it all the time either, things change very, very quickly in the employment law space too.
Yeah, exactly. I'm just going to see if there's any questions coming through. You probably explained everything very well. As you said, we will send through a copy of these slides to help people out. There's, I guess, a lot of information that you gave out today, so seeing the slides also helps if you can keep it on file as well so you can refer back to it. But if nobody has any questions, it is past 2 o'clock, so we will wrap things up. And Kristie, we haven't worked out the date for our next webinar, have we?
I don't think we have. I think we've got something penciled in for June or August. I can't
Yeah,
remember.
yeah, I think it's going to probably be a Friday too, isn't it?
It will, yes.
Yeah, you love your Friday Friday webinars. Actually, Sandy's just sent through a question here. If we have sites in ACT and New South Wales, do we have to pay the LSL in both states?
Can you please contact me, Sandy, and we can have a chat about that one offline? I'll just have to look into it for you.
Yep, no problem. And that's your phone number up there, isn't it, on the screen now? So
it's my direct line in my office, yes.
Great. All right. I'll get Sandy said she'll do that. Well, I shouldn't say she, it could be he. We'll contact you directly. And we will wrap things up. As I said, this will come out as a recording shortly. It'll take a few days before it's up on the website. Once that comes out, I'll also send through a copy of the slides to everybody. If you think of a question after this webinar, please just get in contact with Kristie. That's that's what we're here for. And also, if you want more details about HR docs and HIA apprentices, Kristie can point you in the right direction for those as well. Thank you, Kristie, for putting it all together. I know you've been busy and out in the region, not back in the office for too many hours before you have to do webinars. So thanks again, appreciate it. And everybody have a great afternoon, and I hope everybody has a great weekend.
Great.
Thank you.
Thanks, everyone.
Bye.